Morning, good afternoon, everybody. We'll go ahead and get started. I appreciate y'all coming and watching this. I'll have to admit that I think the last video presentation or webinar presentation I've done for Haynsworth was back in 2019, which was actually pre-COVID, which is odd. I think I was in a video conference room at the time, and obviously the world has changed a lot since then. So I'm gonna do the best I can with technology. I've tried my best to hide from Chris Gant and avoid having to do these webinars. And I actually moved to Columbia from Greenville in 2020 to try to hide, and I was unsuccessful. So here I am. You may see a little bit more of me coming up. But luckily, this is a presentation of at least one thing, non-competes, which is sort of near and dear to me, something I really enjoy. And the FLSA, it seems like I'm always talking about a new proposed rule. So we'll go through that process again. And I'm gonna try to speak slowly, something I'm not as good at, and try to answer any questions that I see. Just bear with me on that. If I'm moving too fast, maybe somebody can tell me to slow down. It's sort of a nasty habit I have. This slide, I will just go ahead and put out a disclaimer. I realize that Clemson is playing North Carolina this weekend, and it looks like it's Tar Heel blue all over the place. And even though I'm not really a Clemson guy, I assure you this was not my doing. I'm not really dear to Chapel Hill either. So I apologize about that. But you can see we have 5 locations now. We have a Raleigh office as well. You can submit questions using the Q&A and chat features. I think you all have probably done this before. Feel free to ask me any questions. This is a recording, and we're happy to share this in this presentation with you, and maybe that'll help alleviate some of my bad habit of moving too quickly. All right, so the first topic is related to non-competes. And really the theme here is that there's been an anti-non-compete sentiment from the federal government over the past several years, really. And in fact, in 2016, the Obama administration, I think in like October, which was shortly before the election, issued some sort of announcement that was trying to get the states to curtail the use of non-competes. And we've seen a revival of that, at least since 2021, when President Biden issued an executive order that encouraged agencies to figure out ways to curtail the unfair use of non-compete clauses. And then it really heated up this year, starting at the beginning of January, when the FTC, the Federal Trade Commission, proposed a rule that effectively bans non-competes. We're going to talk about that and others. And then in February, there was introduction of a Workforce Mobility Act that is actually a bipartisan group of U.S. senators. There's been attempts like this before that we'll talk about a little bit. But this one, maybe feels a little bit different in light of this sort of movement towards trying to ban these non-compete agreements. And then in May, late May, the NLRB had the General Counsel issued a memorandum basically saying that non-competes would violate the NLRA, and there's some limitations to that we'll talk about. But as a whole, the theme here is that there's a growing sentiment against non-compete agreements. It's difficult to tell for sure. I mean, obviously, there's a party element to this, and when the Democrats have been in office, it seems to catch hold more. But it's hard. And listen, I'm not smart enough. I'm not a politics guy. I could probably name 5 senators in the United States Senate right now. It's not something I keep up with, but I'm not sure that this goes purely down party lines. As I mentioned, that Workforce Mobility Act does have some bipartisan support. And so none of these things that we're going to talk about are law yet. But it is something to be mindful of. I don't know how these things are going to play out, but it may not be this year or next year that we start to see a lot of these changes take hold. But if you made me bet, I would bet that in 5 or 10 years, certainly there's going to be some pretty significant changes, because that just seems to be the direction that things are going. One thing to keep in mind as we go through this stuff with non-competes is, remember what we're talking about when we're talking about non-compete covenants. We have a tendency as lawyers and people to sort of generically use the term non-compete, and I'm absolutely guilty of that myself, even though I do these things all the time. But really, there's what I think of as three distinct covenants that are encompassed within sort of the generic term of non-compete. There's non-competition covenants, there's non-solicitation covenants, and non-disclosure covenants. A non-competition or non-compete covenant, when we speak about it more specifically, is one that prohibits somebody, effectively from working for a competitor in a certain geographical area. A non-solicitation covenant is a covenant that prohibits employees from soliciting customers, most commonly, and also employees. We see those kinds of covenants a lot. And a non-disclosure covenant, of course, is one that prohibits the use or disclosure of usually confidential information. Sometimes non-solicitation and really more non-disclosure covenants can be so broad that they effectively prohibit somebody from working for a competitor. And in those incidents, as we're going to see, those are treated like a non-competition covenant. A theme that we're going to see too, even with this new legislation, or this really, I should say, the new regulations that are proposed and the new legislation that's proposed, is that there appears, even if they are passed, to be an opening for non-solicitations to still be valid, and certainly non-disclosures to still be valid. And in many ways, for many employees, especially in the sales context, I find that a non-solicitation of customers is really far more effective and a better way and more sure way of protecting what needs to be protected anyway. So in that sense, as we're going to see, maybe these things are not going to change things as much as we might think, at least for those types of employees. All right, so we're going to start by talking about the proposed FTC rule. I say rule, it's really a regulation. It was first announced or published in January 5th to be specific. It would ban employers from entering into non-compete clauses with their workers, and workers includes both employees and independent contractors, which is not surprising. And very interestingly, it would require employers to rescind existing non-compete covenants and actually actively inform their workers that the covenants are no longer in effect. So it's got retroactive effect. That means current agreements are no longer enforceable if this was to pass. Again, I want to reiterate, and I know maybe y'all may not be as used to thinking about the FTC as you are the Department of Labor. I know that most of you are familiar with Department of Labor regulations. This is the same concept. This is a regulation. As you know from dealing with the DOL regulations and, like the 2016 proposed rule that we talked about, or at least I've talked about with many people several times, regulations can be challenged on various grounds. And that would be a whole other thing to start really getting into the weeds of that. I had an entire law school class just on administrative procedures. And suffice it to say, I do have some questions in my mind about the authority of the FTC and whether this is a rule that would ultimately pass judicial muster, although I have not researched it specifically, and really I've never had to deal with worrying about an FTC regulation before. I think probably even if I went, and it'd be fun, I would love the academic side of going through that and getting to research that. As a practical matter, I think it would be a lot of guesswork anyway, even if I did go and try to really figure out what the challenges would be. I know I was certainly with the 2016 Department of Labor rule on the EAP exemptions. I was dead wrong with what I thought the court was going to do with that. So, I'm not in the habit of trying to predict those things anymore, at least after that incident. So the proposed rule here, this FTC proposed rule, had a comment period. I believe it ended in April or May. It's anticipated the final rule is going to be announced probably sometime in next year, maybe April next year is what I've seen predicted. There's going to be a lag time between the publishing of the final rule and the implementation period. So, and obviously on the next slide here, we're going to talk about what it means in this regulation to be a non-compete clause. So here is that definition. The term non-compete clause includes a contractual term that is a de facto non-compete clause because it has the effect of prohibiting the worker from seeking or accepting employment with a person or operating a business after the conclusion of the worker's employment with the employer. I guess relative to a lot of regulations I see, this is probably a pretty good and simple definition here. And the key feature of it, I think, is that, we don't care what you label this or what you call this. We care about the de facto effect of the covenant. And it gives some examples in the proposed rule. I believe there's more, but I just picked these two out because I thought they were interesting. Obviously a pure non-compete covenant that says you can't go work for a competitive business within 20 miles of existing location for 2 years. That's obviously going to be included in the definition of a non-compete clause here. But it gives these other examples. One of them is a non-disclosure agreement that's written so broadly that it effectively precludes the worker from working in the same field after the conclusion of the worker's employment with the employer. So that's saying, even if you've got some non-disclosure covenant that's just so massively broad that it says, hey, you can't use your general knowledge and skills, we're going to look at that as a non-compete. I will note that in and of itself is not going to be much of a change. Well, it would be from the pure banning standpoint, but the concept is kind of already cooked into South Carolina law. There was a case from back in the 90s called Muck and Fuss is what we usually call it. And then there's a couple of more recent district court cases that essentially say that we're gonna treat a non-disclosure covenant as a non-compete if it prohibits the employee from using general skills and knowledge at another employer. Obviously the devil is in the details as to exactly what is a court going to look at and see as effectively precluding a worker from working in the same field. What does that covenant look like? That's something that the courts are going to have to sort out because it certainly is not very clear just from this definition. The second example here is one that I just, you could have sat there and asked me for examples and I would have talked about it and thought of plenty of them. I would not have thought of this as an example. It's pretty interesting. It says, if you make a worker pay the employer or a third party for training costs, if his employee, if his or her employment terminates within a certain time period, and those aren't reasonably related to the cost that the employer incurred in training, then that has the effect of a non-compete clause, which is really pretty fascinating. And again, the idea is, I guess it would just terminate it would just find that this clause is not enforceable if the employee tried to leave. But then again, if you don't write it correctly, you may lose whatever cost you'd be able to get back. So I thought that was a pretty interesting example that frankly, I wouldn't have thought of as part of this. All right, so here are some of the justifications that, when they issue these proposed rules, they have these just massively long things. If you're ever having trouble sleeping, you can print them out and try to read them because it'll put you to sleep. It's pretty boring. But there are some nuggets here and there that I find interesting. And some of them are some of the justifications that are offered for the proposed FTC regulation. And the main one, I think, at the end of the day is this first one, that the non-compete clauses reduce workers' wages. That was what was cited in that, I guess, announcement or whatever it was that the Obama administrative put out in October 2016. And I guess, and it's also what the Biden executive order, I think, indicated. Obviously the idea is that when you're limiting mobility, you're keeping workers from going somewhere else freely to places with bigger wages. And if the employee doesn't have that freedom, that employee doesn't have leverage to negotiate with you to get more money. If I basically am keeping the employee from going to use, his or her skills and knowledge that they've gained in this industry somewhere else, then, I know that I've got leverage because I can keep them out of work for a couple of years. And that's the idea that's bothering the I guess I say the federal government. I guess it's really more the Biden administration, previously the Obama administration. And I sort of get that. I guess the question is, from a philosophical standpoint, is it worth taking that and sort of interfering with people's ability to contract? And they would say yes. Some people would say no. I'm sort of in the middle. I've been on both sides of these cases many times. I've tried to enforce non-competes and have enforced non-competes. I have also defended them many times and said they're unenforceable. And frankly, I just really enjoy the exercise of trying to attack these non-competes, and it would be far less fun to me to do that if there's just an outright ban so greedily. I kind of hope these things don't take hold just for that reason, but I can sort of see both sides of the equation. And as we're going to see a little bit later, this concept of the bargaining impact and reduction of wages kind of cooks itself into the NLRB's concern that we'll discuss in just a little bit. Here, there's a note that the FTC estimates that the proposed rule could increase earnings by a total of $250 billion to $296 billion per year. It also references closing the racial and gender wage gap by 3.6% to 9.1%. I read that in the proposed rulemaking and was kind of interested as to why. And I just haven't had time to think through it myself as to why this would have that impact. I guess maybe certain people are more likely to have these kinds of agreements, or maybe they are less likely to fight them, or there's some other sort of discriminatory impact with these. And maybe that is described in the proposed rulemaking, which I didn't read every word of that, but I thought that was kind of an interesting point. And then there's non-compete clauses stifle new businesses and ideas. That's a pretty obvious one. Somebody who has, the desire and innovative ability to go and do a new business is maybe not able to do so. And so, you're basically, you're going to have less competition. And they make the point that it leads to higher consumer prices. And it talked about the healthcare industry in particular. But certainly you can see if there's less competition, then I guess theoretically there's higher pricing. I'm certainly far from an economist, but I think that's what that's trying to get at there. This is just additional justifications that were offered. Obviously, there's the worker exploitation and hindering of economic liberty. To me, that sort of is the same way of saying that there's the wage issue, and I guess also other terms and conditions of employment. You might have a situation where you're not getting along well with your supervisor, or you just don't like the company's culture, and maybe you're not a great fit for that culture, but you're sort of forced into staying in that position because of a non-compete agreement, which the Biden administration at least would say is not proper. Employers have other ways to protect their legitimate business interests is another justification that's offered. The FTC in this proposed rulemaking made the point that I guess California, North Dakota, and Oklahoma have banned non-competes, and they say that the data show that these states have had flourishing of key investments in trade secrets despite this ban on non-competes, which they say is proof of other legitimate other ways to protect those interests. And obviously some that we're going to talk about is a well-crafted non-disclosure, non-solicitation agreements. Also protecting information, making sure that if an employee does leave, that he or she's not taking any stuff with them. And certainly there's various ways to do that. There were comments sought by the proposed rule, which, as you all may know, what the idea here is they issue this proposed rule. They give you a certain time period to provide comments. That time period is now closed. FTC is then supposed to review these comments and based on them issue a final rule. Sometimes you can gain, and by the way, obviously the final rule can be different from the proposed rule, as I'm sure you guys know. So sometimes we can read into these comments that were solicited and sort of figure out maybe what else the FTC or whoever the agency is thinking. Here the FTC One of them is about whether franchises should be covered by the rule. That one is just a little less interesting to me. One of the comments that they solicited was whether senior executives should be exempted or subject to a rebuttable presumption rather than a ban. And I thought that one was pretty interesting because I could totally see a distinction there being made on various grounds. I mean, one being, if we're worried about lower wages, I guess it's all relative, but maybe we're a little bit less worried about the people who have really high wages than we are the people with really low wages, and worrying about what impact these agreements have on that. I think another pretty big distinction between maybe a senior executive and somebody who's lower on the totem pole is the ability to protect yourself. If we're going to interfere with the right to contract, maybe it's more justified when it's somebody who has less ability to protect themselves. They don't go talk to an attorney before signing the non-compete, and maybe they don't talk to an attorney after they've signed the non-compete and they want to leave, or they don't have the resources to fight it. I mean, it's amazing how many times the advice that I give people, if an individual comes and asks me, they say, hey, I'm interested in leaving, but I want to understand, I may look at that agreement and say, look, I'm never guaranteeing anything, but I really think if you fight this, it's probably unenforceable. And I think a judge would probably find that it's unenforceable, but you got to fight it. And, you may get outspent, and that's just a reality of the situation. You may never get that money back, and you may spend a year, 2 years, 5 years of your life fighting this thing, and that's just a practical reality of it. So, senior executives are in a better position both to look at it and analyze it on the front end, and also to fight it on the back end than maybe somebody else. So I could totally see the FTC making a distinction there. And of course, once you make that distinction, then we get to figure out what does it mean to be a senior executive, and there'll be a million more regulations. And, I mean, sometimes these regulations are like a cancer that, they just grow and grow and grow and get bigger and bigger at an exponential rate because one regulation leads to three. So anyway, we'll see if that's what happens. And then similarly, whether low wage workers should be treated differently from high wage workers. I think that's kind of another way of saying the same thing as the second comment that they were soliciting there. So here's, and I've sort of covered this a little bit, here's the status of this rule. Again, it is not a rule now, it's just a proposed rule. There will be a final rule that, according to what the internet says, which, never lies, is expected to be voted on in April 2024. I don't know if that's based on just an estimate based on when they proposed it, but that's what people are looking at. And so the final rule, as I mentioned, could be very different. We've seen that before. Doesn't have to look similar. There could be some different iterations. We could see that distinction between executive level or higher wage employees be implemented in the final rule. And again, I would expect there to be some significant and substantial legal challenges to it. There could just be challenges on the front end, but I mean, gosh, you got retroactive application here. I mean, who knows how many cases across the country are pending right now. I mean, I've got several of them that involve non-competes. And the minute this thing goes into effect, if it's retroactive, I mean, you're going to see everybody filing motions. I mean, unless there's some exception for that. I mean, I'd be filing a motion immediately for summary judgment or whatever. And I'm sure that the other side will, then argue, well, no, this was not a valid rule. It shouldn't be implemented. And, and then you might get some sort of injunction as part of that litigation. You might get a federal court, just like you did with the 2016 FLSA rule, that enjoins the implementation of it on the front end. So I just can't imagine that there aren't going to be significant legal challenges to this immediately. And I am not going to sit here. First of all, I haven't researched this in particular, but every time I try to predict what courts are going to do with this kind of stuff, I've gotten it wrong. So I'm not going to try to predict what's going to happen with that. But certainly there will be challenges to it. Significantly, we're going to talk about this at the end of talking about all these new non-compete things. The proposed FTC rule would not ban properly tailored non-solicitation covenants. It's not going to ban properly tailored non-disclosure covenants. Again, non-solicitation covenants are often more effective, at least in South Carolina anyway, at least for salesmen, in protecting customer relationships. And we're going to talk about that at the end of the non-compete section of this. So the second new sort of federal anti-non-compete thing is Workforce Mobility Act of 2023. Again, that was it was introduced February 1st. It was a bipartisan group of U.S. senators. You can look up and see who they are. I don't know who they are. You can figure it out. There are, just as I noted, this is not the first time. This isn't something that is brand new, at least from that standpoint. And apparently it hasn't gotten any traction. There were the most recent prior effort was in 2021. They didn't make it to a committee vote, which you guys are probably in a better position. I remember that little cartoon with the little paper bill walking around and showing us how he becomes law. But it's been so long, I can't remember. I usually just worry about the laws after they're passed. So I'm not going to predict whether or not this thing gets passed or not, but I do think that it's interesting in the context of it being something that seems to be gaining more traction overall. This Workforce Mobility Act, from a substantive standpoint, it's got some similarities and some differences. It prohibits the entering into a non-compete agreements, which it defines. You can read it in the second bullet point here. Really any agreement that prohibits the employee from performing any work for another person for a specified period of time, any work in a specified geographical area, or any work that's similar to such individual person's work that is party to such agreement. I mean, I'm a little, well, first of all, I'll mention one thing that's not in here is this retroactive effect business. So if the FTC rule doesn't go into effect and this one did, you're not going to see this retroactive, all these immediate motions getting filed. You've got this after enactment limitation that you see here in this definition. So anything already in effect, I guess, would be valid. The other thing that is just confusing to me is what does any work mean? I'm not 100% sure that I know exactly what it's trying to say there. And so I'm not 100% sure on this one whether or not it would abandon or whether or not it would prohibit non-solicitation agreements. I think probably it would not. I don't think that's what it's trying to say, but that definition, I'm just not 100% confident in that. I'd have to look it up a little bit more. My guess is probably non-solicitations, if properly tailored, are okay, but I just am not 100% sure. There's also a requirement you got to let the employees know about it. Again, the status, this is just a proposed law. It's unclear to me whether this is going to gain sufficient support to be passed into law. If it passes, I think that Biden would probably sign this. But that's not very clear to me. Is it exactly what's going to happen? Again, I don't know whether it bans non-solicitations. I think probably not, but I'm pretty sure it would not ban an appropriately tailored non-disclosure agreement. So the next and I guess final sort of thing that's happened in 2023 as far as anti-non-compete efforts go is this May 30th, 2023 memorandum from the NLRB General Counsel, who basically set forth her view that the proffer, maintenance, and enforcement of non-compete provisions in employment agreements and severance agreements violate the NLRA except in limited circumstances. So I mentioned this earlier that the NLRB filters in, especially with bargaining power, as we're going to see. Just a reminder, I know you all know this, the NLRB, National Labor Relations Board, is of course a political board. It changes depending on the administration, so you always need to keep that in mind. And also, this is not law. This memo is not even like the NLRB's decisions. It's just sort of an idea of what the field people are looking for from an enforcement standpoint, and also kind of interesting in the context of what else we've seen with non-competes this year. Just to give you an idea, the memo, it basically says that these non-compete agreements chill employees' exercise of rights under Section 7 of the NLRA, which is the section that protects their rights to take collective action to improve working conditions. So specifically, she says that the general counsel says that they interfere with the employee's ability to concertedly threaten to resign and get better working conditions, concertedly seek or accept employment with a local competitor to obtain better working conditions, or solicit their coworkers to go work for a local competitor as part of a broader course of protected concerted activity. I thought that one was kind of interesting, number 4 there, because up to this point, we haven't really talked about non-solicitation of employees. And that, I've got a case now that deals with some of those covenants. A lot of times they're a little bit of an afterthought, and courts treat them differently in different jurisdictions, maybe as much or more than the other covenants. It's hard to get to synthesize all of these things, based on all the different laws. So I did think that drawing in a non-solicitation of employees covenant into this analysis was sort of interesting and different. Again, this is not binding precedent. Ultimately, the NLRB decisions would govern, and even then, it's a political board. And I will note there was a recent NLRB decision, which is actually, it's this Stericycle case, which was actually referenced in the memorandum that the general counsel wrote, where I think she was encouraging the board to hold a certain way against these non-compete agreements. And there's this language in that opinion that says there's no basis to support that the non-compete agreements would have a reasonable tendency to chill employee Section 7 rights. They're specifically designed to address issues outside of the purview of the NLRA. Now, I'll be honest, I haven't really read that opinion to put that language in context, but I thought that was, that's not necessarily boding well for where this is going to go for the NLRB. But I'll also note that there's currently a case that's going up, that's scheduled to be heard November 28th, that deals with these issues. So, it's always possible that this is something that all of a sudden catches on. It's important to note the impact, again, is not binding, but even if the board issues a decision, the NLRA doesn't protect supervisors and managerial employees. So really it wouldn't apply to them. Theoretically wouldn't apply to a non-compete that they have. I don't know whether it would apply to a non-solicitation of employees that they have, because if it prohibits them from soliciting lower level employees, it obviously has a chilling effect under what is protected. But so that would be a pretty interesting issue as to how that would play out. Certainly doesn't affect non-disclosure agreements unless they're overly broad, like we discussed, if they have the effect of a non-compete. And they should not affect customer non-solicitation agreements either, as long as they're properly limited. So in light of all of these decisions, what does this mean for y'all? And I always love it when I can give a presentation on something and talk about something for a long time and then say no effect, it doesn't matter. And I again, these aren't binding, so at least at this time, that is true, that probably they don't have a practical effect. But I would be pretty conscious of what's going on, because it looks like the FTC is going to do something, and I suspect that in the long term, even if things kind of cool down now, this is something that's going to happen, that non-competes are going to be so disfavored that they're unenforceable. And as a practical matter now, they're pretty tough a lot of times unless they're really well crafted anyway. But a key aspect of all this is that even these proposed rules don't prohibit a non-solicitation of customer provision. From what I can tell, again, there's sort of an issue under that Workforce Mobility Act as to what it does, but these are still valid. And in a lot of the agreements that I wind up drafting and looking at is the non-solicitation of customer provision that I feel like offers the most protection, certainly in the context of a salesman or somebody who's dealing with customers. You know, that's what's scary is you've got somebody out there who's got a whole bunch of customer relationships. That's what customers are looking for, right? I mean, that they want to feel like they've got you know, a continuous level of service. They want their comfort level. And if you have to bring in somebody new, they're more likely to go with the person that left. And so if you have an appropriate non-solicitation, you know, and maybe even one that prohibits servicing of customers, that's another, you know, that's an interesting issue as to how that would be treated. But, you know, those are probably more effective in the context of those employees anyway. Appropriate non-disclosure covenants, I think, are certainly still valid under any of these rules. You know, the problem with those, and you should always have them, there's no harm in having them. You know, the problem with them is it's just like, how do I enforce that? How do I know if they're using my information? And I don't usually have a very good answer for that, but, you know, it certainly does not hurt to have them. And certainly, you know, if you find out that an employee has taken confidential information, these can certainly be helpful in that context. So because non-solicitation covenants maybe have risen to even more important level in light of kind of what we see catch and hold now, I've got a few pointers that I've listed here, and I want to be very clear that these are not the only issues. I mean, this isn't a list of the criteria that these have to meet to be enforceable. These are just common issues that I see when I'm evaluating it, you know, both from a drafting standpoint or in litigation when I'm trying to attack it. You know, the first thing, at least in South Carolina and really in a lot of jurisdictions for non-solicitation of customers, is it needs to be limited to customers with whom the employee had contact. I would say at least during the final 2 years, but to be really safe, I'd say during the final 12 months of the employee's employment would be a more appropriate time period. Arguably, you could also include a limitation of customers about whom the employee had confidential information. I'm not as clear about the enforceability of that. If I was drafting it, or when I draft these, I kind of separate those out so that maybe if that information one is unenforceable, then the court could, you know, that could be stricken, and the court maybe could just enforce as to the customers with whom the employee had contact in the final 2 years or 12 months. Also, make sure to limit it to solicitation is for the purpose of a competitive business. For example, a widget manufacturer shouldn't keep its salesman from soliciting one of its customers or buyers for the purpose of a landscaping business. You really don't have any legitimate interest in that, because, you know, he's still going to be buying widgets from you supposedly. Those kind of little pitfalls, or they can be a problem and render the entire thing unenforceable. I would say 2 years restriction at the most. I wouldn't do more than that. 1 year is safer. 2 years probably okay. I wouldn't go beyond that. Prospective customers is a big issue that I see. There's a South Carolina trial court opinion or order that I'm aware of that says that prospective customers is not valid. That's overly broad. And, you know, if you just say customers or prospective customers right there in the same covenant, they're going to strike the whole covenant and say it's all unenforceable. So if you want to include prospective customers, what I do when I draft them is I put it as a separate covenant, because that way it at least increases the likelihood, and I think the court should be able to just strike that covenant and enforce the other one. There's some argument maybe they would all fail if you do it wrong, but I think there's a pretty good argument that at least you could strike the prospective customers and then be able to enforce the rest of it. It's amazing that that usually doesn't happen. I don't know why people don't draft them that way. I'm kind of glad they don't, because when I get cases that have those things and I'm on the other side, I can attack them. But for some reason that I see that problem a lot. From a non-disclosure standpoint, confidential information should not be defined so broadly to include general skills and knowledge. There is one case in South Carolina that addresses this. There may be more now, but this Milliken versus Morin case from 2012. And so it sort of is the guide post here, and it enforces the confidentiality provision there because it was limited to only important information not generally known to the public, which becomes known to the employee through his employment with the employer. And in that case, interestingly, there was a time limit. I mean, it was maybe 5 years. or maybe it was 2, I can't remember. And the court said we don't have to address whether there needs to be a temporal limitation because there was one there. You know, so there's some argument that maybe a non-disclosure covenant needs a temporal limitation. Certainly it doesn't for trade secret. I kind of hate to put one in there because I don't want it to be okay for them to use it after 5 years, but there is that kind of issue out there that I will note, and I don't know what the answer is. A lot of times I draft them without those temporal limitations, just with the warning that maybe a court would come back and say this needs to be crafted with that limitation. But I feel like if you appropriately define what confidential information is, you shouldn't need the limitation, because when it's not confidential information, if it's no longer protected, it should be okay to use it down the road anyway. It's just that we don't know when that might be. One quick note, I've got just remember, consideration is always a problem when we're talking about any of these covenants. Continued employment in South Carolina is not sufficient consideration. There's also this case that's kind of recent that came out. I was going to go through it if I had time. I don't think I'm gonna have time though. It's pretty interesting. Basically what happened there is the employee had an agreement. He entered into it like years after started employment, and they were gonna increase his base pay and do some other things, and he did get his base pay increased, and also got like a ton more money ultimately. But you know, the ton more money wasn't part of the recited case. You know, he would have gotten that anyway, arguably, because it was like bonuses and stuff. The increase in base pay, there was an increase, it just wasn't as much as what the agreement said. And so that was pretty interesting to me. It's like, if you're going to put in the agreement exactly what the consideration is, you better meet what you put in that agreement, is how I read that order. Now, that was just on a preliminary injunction. That case is still pending. There could be a different ruling down the road on it, but I thought that was sort of an interesting little warning. So I'm going to close out the discussion of the non-compete section of this. I don't see any questions on it, and so I will move on. The FLSA, I feel like we're always doing this. Another proposed rule. It's interesting. This is, of course, this is a proposed rule for the executive, administrative, professional exemption that exists in the FLSA. It's interesting. Maybe somebody knows the answer to this, but we do this all the time, and we did it in 2016. This happened in 2019. We're doing it again now. Is this obsession with the EAP exemption, executive, administrative, professional? I say EAP. I don't. It's funny to me. Minimum wage is just kind of sitting out there at $7.25 an hour. I don't know why that doesn't. Nobody seems real concerned about that, but we're obsessed with this. I'm sure somebody smarter than I am knows the answer to this, but anyway. So this is, again, as y'all remember, and we'll talk about it in a second. The salary level is part of the analysis for this, and this proposes to increase the salary level. This was published September 8th in the Federal Register, and the public comment period closed November 7th, and then a final rule is anticipated sometime in 2024. So just to put this in context, minimum wage, OT, that's what the FLSA is. This is the exemption for EAP. The test to qualify as EAP is salary level, salary basis, and job duties. The salary level and the salary basis test is identical for executives, administrators, and professionals, but the duties test for each is different. This proposed rule only deals with the salary level aspect. So it applies to all three of them, but only to the salary level. It doesn't change the duties test. Highly compensated employees, we call them HCEs here when you see that, are people that require less of a showing under the duties test. We don't have to worry as much about the duties test, which is a nightmare of complication if they have a higher salary, but they have to have a high salary, and this changes how high that salary is. There's also, just a reminder, this doesn't apply to all professionals like doctors, lawyers, teachers, outside sales. They have their own little thing. So the proposed rule increases the salary threshold from $684 a week, which is the 2019 rule, to $1,059 a week, which is the proposed current rule. That's $35K a year, roughly, to $55K a year. This is the proposed salary is the 35th percentile of weekly earnings of full-time salary workers in the South, which the South is always the lowest in the United States. So really, it always just says in the lowest of the United States. but that's always the South, so I usually just say in the South. The highly compensated employee is a raise from 107,000 to 144,000 almost. So a pretty big increase there as well. And that is the 85th percentile of salaried workers nationally, not limited to the South. Interestingly, and this is something new, we've got a automatic update now. Every 3 years, the minimum salary level is going to be updated automatically to the 35th percentile of weekly earnings of full-time non-hourly workers in the lowest wage census region, which is going to be the South. I think it's probably always been the South. And then same thing for the HCs, there's going to be updated to the 85th percentile. So I guess we won't have to go through this all the time. It kind of makes sense. Let's just kind of run with inflation based on percentile of salaried workers, but that is something new. This hasn't been done before. They will publish, thankfully, what the actual amounts are 150 days before each update. Interestingly, too, under this proposed rule, I guess they could change this part of it, but there would be only 60 days between adoption, publication of the final rule, and implementation. That's a pretty quick turnaround. I don't think it was that high in 2016 or 2019. So it's kind of like get ready. They're anticipating the final rule would be published sometime in 2024. Again, the FLSA is not going to change the duties test. That is the most subjective duties test. I mean, the most subjective test in all of this. And unfortunately, the way the court has examined this, it's like you should only be looking at duties, maybe, or just salary should just be a proxy to it. And if Denny Major was a czar and we wanted to have these rules there, I would get rid of that stupid duties test. I just feel like it invites bureaucracy and administrative cost, and you get a whole bunch of people trying to analyze it. If you get 10 people to look at whether somebody meets that test for anybody that's on the periphery, you're going to get 10 different answers. I mean, it's complicated. It would be so much more efficient, which is apparently not what we care about, but so much more efficient to just use the salary level test. But I'm not the czar, and this is the world that we live in. It also does not revise a rule that allows, and this was something that was implemented in 2019, to permit the 10% of an employee's required salary amount of you can allocate 10% for non-discretionary bonuses as long as they're non-discretionary, and then you true it up on a quarterly basis. So that is still part of this new rule. It's just that the salary level is higher. So just some interesting notes. Like I said, when they do these rules, they give us a whole bunch of information that is kind of interesting if you can weed through all the other stuff. Some of it's interesting. The DOL estimates that the change in this salary level is going to impact 3.4 million workers who are currently exempt, but they earn between the current, $684 a week and the proposed $1,059 a week. So all of a sudden, you're either going to have to change these people's pay, or they're going to have regular wages and be entitled to overtime. And then the DOL thinks that there's going to be almost 250,000 employees who are affected by the proposed highly compensated employee increase. There's also this economic impact in the form of transfers of income from employers to employees of 1.3 billion with a 7%, and that's, I think, annualized with a 7% discount rate. So I thought this was kind of interesting, what this rule looks like compared to the other rules. You've got the 2016 final rule, which wasn't implemented, but there was a final rule, with the 40th percentile for the salary, the standard salary, 90th for highly compensated employee. Remember, federal court issued an injunction, so that's not enforceable. And then there was an appeal, but that got mooted because there was the election, and Trump administration wasn't going to try to overturn that. And then there was the 2019 rule that mooted it as well. The 2019 rule, which is the current rule, has 20th percentile of full-time salary workers in the South, and 80th percentile for the HCEs. Interestingly, so the 20th percentile is the same as the 2014 rule. So it's like, it's just, basically we just adjusted in 2019 for for inflation. Inflation's a rough term, I understand, but that's essentially what they were doing. The 35th percentile and 85th percentile that are being proposed now is a little bit lower than the 2016 rule that was not implemented, but I think it's a lot closer to the 2016 rule than it is to the 2019 rule. And to show that, I did this little chart, which I hope is correct. But this is the 2004 rule, which was 20th percentile. It was, $23,660 a year. And then they wanted to bump that up to over twice at, 47,500 almost a year in the 40th, that was 40th percentile. And then 2019, we took it back down to 20th percentile, but obviously the raw increase was significantly higher because of the 15-year gap there. So now we're taking it back up to the 35th percentile again, which looked a lot closer to the 40th percentile and than the 20th. Interestingly, there's some note that maybe it can be bumped up even higher, closer to 60,000. There's a footnote, I think, in the proposed rule. So the final rule could look different. It could be even higher. The HCE stuff kind of splits the difference. Apparently back in 2004, that was the 93.7th percentile. It looks like they just must have picked 100,000 as a good, good bright line number that they liked with the 6 figures and didn't worry as much about what the percentile was. And now they're concerned about the percentile. So 2016 was 90th, 2019 was 80th, and this one splits the difference at 85th. But the practical increase is higher than the 2016 rule, I guess, because of the inflationary aspect of this. So how does this look moving forward? The comment period is closed, so now the Department of Labor has got to look at their comments and issue a final rule. I'm not sure how many comments there were. I couldn't figure it out. You could probably look it up. I'm sure there were a lot. And the final rule very well may change. Again, I mentioned this earlier. There's a footnote in the proposed rule that suggests that the final rule could have a salary threshold as high as $60,209. So legal challenges are almost certain to follow. And I'll note, we talked about the 2016 rule, as y'all know, it was challenged. There was a Texas federal court that issued an injunction. The rationale was that the new rule makes overtime status depend predominantly on a minimum salary level, thereby supplanting an analysis of an employee's job duties, which is like a nightmare, in my opinion, just because it's like, I hate job duties, it's so complicated. But that, I guess I get it. I sort of see what it's saying. Certainly that rationale would apply equally, I think, to the 2023 rule. It should be noted that 2016, federal court's order was appealed and it just got mooted. So it's not like, it couldn't be overturned. On that point, the 2019 rule, which was implemented, was also challenged in Texas federal court. And there was actually an order on summary judgment entered in September holding that the Department of Labor has statutory authority to impose that salary requirement. I just checked the docket on that, and that decision has been appealed, which is to the 5th Circuit. I don't know when it would be decided, but I would think that the decision that is issued there would have would have some impact on what ultimately gets decided, and may wind up in the Supreme Court. But that is one to watch as well, to see whether the rationale holds in the 2023 rule, whatever the rationale is provided for in the 2019 rule that's currently on appeal. Again, 60 days is a short turnaround, so it's pretty important to be ready. It's probably a good time to be taking a look at the financial impact of this increase, look at who should be reclassified from exempt to non-exempt based on duties, and whether or not, from a practical standpoint, it's more efficient to do a salary increase or whether to put them on hourly. The duties test has to be a component of this. That is part of the test, and even if they're a highly compensated employee, it's part of the test, although less so. But it's supposed to be really the primary test, according to the Texas federal court. So that's a pretty important part of the analysis. There could be opportunity if there's people that you think may not meet the duties test, and maybe you looked at it already and you thought, gosh, I mean, we're not sure if they meet the duties test, but you don't want to change them because then it's going to, you know, prompt them to realize that maybe they've been improperly classified and think about filing a lawsuit. This kind of provides you some cover, like, oh, well, we'll reclassify you now if the salary test has changed. So, you know, maybe I've had that come up. So maybe at least in those instances, it's a little bit of an opportunity. Remember, the South Carolina Payment of Wages Act requires notice for any change in pay, 7 days advance written notice. So that needs to be done. A letter to an employee. Job descriptions need to be edited where appropriate. And, you know, you got to think about timekeeping issues, record keeping for timekeeping, and all of those considerations that I know you guys are accustomed to. So anyway, I really appreciate your time. I'm pretty close to being out of time. I don't think I see any comments unless I just don't know how to use this. You know, certainly if you have any comments, feel free to reach out to me, and I'm happy to try to answer them. And I think we'll be submitting the presentation to you, or at least maybe it's available in the link provided. And I'm happy to help out as I can. And I appreciate you all listening to my presentation today, and hopefully you're still awake. Thanks.
Thanks for joining this webinar presented by Haynsworth Sinkler Boyd. To learn more about the firm and its services, visit hsblawfirm.com.